All right. Good morning still. Welcome.
Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
And we have a quorum.
All right, good. HB 537, Representative Tillman's not here. We're going to skip over that. Franklin, you want to come up and kind of give the committee an idea of what this legislation does? I think it's just a modification of what we passed last year.
Yes, sir. Thank you very much. Franklin Johnson with Realtors. This HB 474 is an update to the squatter bill passed last year. It clarifies.
Got a motion for a favorable. Got a second by Senator Stutz and question by Senator Coleman Madison.
Can you tell us what the update is?
Yes, ma'am. It clarifies some of the jurisdictional issues between like the county law enforcement, municipal law enforcement, and some of the processes that we found from implementation issues when someone was to bring an affidavit into the law enforcement. Sometimes they were being rejected by law enforcement. So it clarifies that you can't just outright reject. It also expands it so you can use it if you have vacant land and somebody's on your land, commercial property, that kind of thing.
Okay.
Yes,
thank you.
Senator Gavan.
So I'm supportive of the bill. I am concerned about some of the language in here where we talk about the definition of a power of attorney. I mean, I don't want this definition of a power of attorney to bleed into anything else. I'm probably going to put an amendment on here that says this definition is only for this section and nowhere else.
That was pulled from another section, so just so you're aware.
And any more questions or comments, committee members? Got a first and a second. Ms. Ogden, if you'll call the roll for me.
Senator Albritton? Aye. Senator Bell? Aye. Senator Carnley? Aye. Senator Coleman Madison?
Aye.
Senator Elliott? Senator Figures? Senator Gavan?
Aye.
Senator Smitherman? Senator Stutz?
Aye.
Senator Weaver? Senator Barfoot?
Aye.
8 in favorable.
All right, bill's given favorable report. Thank you. All right, next up, HB 527, Representative Holk-Jones.
Good morning. Thank you, Mr. Chairman and committee. HB 527 creates limits of liability to the person that operates an off-roading park. Claims due to the fact that it's an inherent risk. It mirrors the equine world, the horse world that has had that bill for years and years, limiting that liability, but it also does require specific signage, as in the equine world, and does require them to have liability insurance, $1 million, $2 million aggregate.
A motion for favorable by Senator Carnley. Senator Bell seconds that motion. Members, any questions or comments on the bill? Any opposition using previous role? Hearing none, bill's given favorable report. Thank you so much.
Thank you, Mr. Chairman. Thank you, committee.
Representative Tillman, come on up and tell us about HB 537.
All right. Good morning. Thank you, Mr. Chair, committee members. 537, HB 537 actually deals with crimes that fall under the Aniah's law. And what this bill would do is once the Aniah's law hearing has been conducted, you'll allow the defendant at that particular time to bound the case over to the grand jury.
Tell me, because we had lengthy conversation on the floor, I think there may be some opposition out there, but as I understand it, in different counties throughout the state, I always felt like or thought that district courts were the ones who were handling Aniah's law hearings. Evidently, there are parts of the state where circuit judges are actually handling an Aniah's law hearing, and you have filed, or defense attorneys have filed for a preliminary hearing, and you've had the Aniah's law hearing with a circuit judge in some cases,
yes.
And then you go back to a preliminary hearing in front of a district judge, and they could actually come up with potentially different things. That the circuit judge handling the case says, hey, I think this person's a threat to society, and so I'm not going to give them a bond. And then a preliminary hearing had by a different judge at the district court level, you could come up with they'd say there's not enough to bind them over to a grand jury.
Absolutely.
Under the way that system is set up now.
Yes, and that's correct. Namely, Jefferson County and other jurisdictions that I've been in front of, where the circuit judge is the one that is conducting an Aniah's law hearing because it's happening within the first 72 hours. So once that hearing is conducted, you're finding a probable cause in a hearing as well as the bond. Then the case is going down to the district court. And most district judges are saying you already had a probable cause hearing. So we're just going to bound it over to the grand jury. So the point was to help with court efficiency and make it a seamless process at that particular point.
I understand. You got a first by Senator Bell, second by Senator Van. Senator,
One question.
yes, sir, go right
I know
ahead.
who you mean.
Albritton.
Yes, sir. My concern is we're cutting to the chase. I worry about cutting to the chase too quickly. Because if you're going to have a Aniah's law, that's held within 72 hours. Preliminary hearing can take longer than that.
Yes.
And some preliminary hearings need to be held. I know they get waived a lot, and I know that there's a lot of times when it serves other purposes, but really and truly, that's an opportunity for the court to have some say as to whether there is a justiciable action. Is that the correct word? That there's enough evidence to move forward with this. And I don't want us to get moving too fast along this line so that we have one hearing for one purpose and the preliminary hearing gets sidetracked or eliminated, and thus the ability for the court, whatever court it may be, to put the eyes on it to determine whether there's enough evidence to move forward. Am I making any sense?
Yes, you're absolutely right, and I agree with that point.
So how do we protect that?
And that's the only issue that I see, because once, for example, I had a Aniah's law hearing, and it was 72 hours, right?
Right.
And then I filed for a preliminary hearing, which happened, we'll say, 30 days later. And once the judge reviewed it, he said, you already had a probable cause hearing. I'm not going to address bond, so we're going to waive it to the grand jury. He's going to bound it to the grand jury. I understand your issue, because to me, that's how it should go, and that's how it should. But for some reason, in certain jurisdictions, that's the hang-up with it. But I understand your problem with kind of expedient and rushing it through.
As a defense lawyer, when you get, in many cases, appointed or you get hired late, and some along that line, and you get hired after an Aniah's law, then you've lost that opportunity to find out what the evidence is.
Yes.
So I'm concerned with going
Rushing it through.
along this line. So
That's a
anyway,
good- that's a good
I've got a
concern.
problem with this a little bit, but I'll
Yes.
shut
That's
up.
a good concern, Senator, and I understand your concern with that.
I think there was some discussion that we've had with Senator Smitherman about trying to maybe, even if we said, okay, the Aniah's law hearing shall be had in district court, that would probably, because the Aniah's law hearing, it just says a court or the court. It
Yes.
doesn't specify
Which
district court. So Senator Bell had a comment or question.
Basically, I think we all agree on what you're saying, but unfortunately, in the practice of law, most of the judges are saying you had your hearing, that's it. And I think we both have
Yes.
seen that you got it, we're not going back. And the
That's
ju-
my
and the- and the ju-
problem.
and the
But the
judges-
72-hour hearing, 72 hours is more like a bond hearing. It's not an evidentiary hearing.
It's
And for judges to make it just or you've already had that, you've already been before a judge, that doesn't mean that you've investigated or the defendants had an opportunity to take a look at what the evidence is. I just disagree with where we're going on with this. So
yes, and I completely understand. The only difference is, in order to establish the bond hearing, you got to find probable cause. So that's the reason why we're here, and we got to show that a crime occurred. So if a crime is shown that it has occurred with the probable cause hearing, then now we can address bond.
well, you determined whether a crime has occurred, but preliminary hearing, now you're dealing with if this person did a crime.
Yes, but
There's a different question.
Yes, it's a different question, but I think that's the reason why we're there at the Aniah's law hearing in the first place, because regardless if the person had, say for instance, the person does not have a felony background, so you charge with one of the listed charges. So now we have to show that a crime was committed, and the crime was committed by you to determine whether or not we're going to no bond you as well. And even in the law, it states probable cause hearing in the Aniah's law.
The only thing my boils us down, the court's convenience does.
Understand. Good point. Senator Cole-Madison.
All you learned lawyers around, and I'm just asking a question as a lay citizen. So does this negate the person from presenting evidence? I see where Senator Auburn is going. It's not Auburn?
Because we already got the money out of the budget, Senator.
You know, there are other names that I have for you. I won't use those.
I'm completely staying out of this.
So does that mean that there's no opportunity to present other evidence? I'm trying to understand. This is a very short bill, not even a page. So somebody explain it to me.
I'd say this, and I haven't had one of those in a law hearing, but I suspect as a practical matter, the discussions and the things that are presented at an Aniah's law hearing are almost duplicative to what you would have at a preliminary hearing. Is that
That's true.
fair
That's true.
assessment from what you've seen?
Same officers will testify. Pretty much the same evidence will be presented at the preliminary hearing. But I understand the committee's concerns on the length of time. And I don't have a problem with trying to work the bill to make it, more palatable to the committee, so.
With that being said, is it your desire to carry it over, or would you like to work after if we were to?
Yes, I'd like to carry over and try to work and see if we can figure out more definite terms with that.
Understand. Thank you for being here and appreciate you bringing this to light and letting us discuss it, and I know you'll be back next year with it.
All right, thank you.
Thank you.
Committee members.
All right, HB 449, Representative Robbins.
Thank you, Chairman. Thank you, committee. My bill, what this is, 449, it creates the crime of genetic theft. So what that would be is we have a first degree and second degree. First degree is basically where you take someone's genetic material without their consent, and second is when you use their genetic material without their consent. With the issue of 23andMe and the bankruptcy and what happens with all that data that's floating out there, the question kind of is where this bill came from, and found that other states have this crime if an individual accesses genetic data without permission and then uses that genetic data without the permission. And we make exceptions for law enforcement and for HIPAA and public university that might use that data.
Okay, Senator Stutz.
Thank you, Mr. Chairman. Give me an example of where this might be used inappropriately.
Well, there could be, let's use the 23andMe example where you've given your data over, which would be your genetic data. Well, if someone was to, and some of this is more looking towards the future, if I could access and hack into that system and I obtain your data, so I have your data set, so I could then, I'm not exactly sure where you might sell that data or how you might use it, but the theory is that in the future there could be ways in which that data would, one, it has value and you stole that from someone, and two, it's your genetic material, it's your private information, which should not be taken, and that's the big thing. But I guess your concern is how do you use that data? But I think on the front end, the question is, should someone have that data and have access to your genetic material or your genetic information without your permission, is the first question you'd ask. And to me, that is something we do need to criminalize if you obtain that without permission. But then the second question, or your question, is what is being done with that? And I would say that in the future, there will be, as we move more and more toward biometrics and if that kind of access, whether it be through currency, whether it be through access onto technology, that having control of your genetic data would be vital, and it could be used in a way in which to access information on your behalf.
So this is something that hadn't been done, but it could be. Is that what you're saying?
Well,
I guess where I'm thinking is maybe an insurance company could deny you coverage because you carried some genetic risk for.
I mean, that could be the case at some
I'm just
point.
trying to think of a scenario where this would be used.
Well, I could say from a marketing standpoint, I mean, information is king, and so whenever if you had somebody who had, within their DNA, some disease, underlying disease potential, and that information is sold to, a marketing firm or drug manufacturing firm that may continue to market that, product that.
And I would say that's the more immediate concern of what what I've heard from researching this issue is the idea that then if we know from your genetics what, as you say, you might be predisposed to a condition, or you have an underlying, genetic marker for that condition, well, now a marketer or a company could market products to you and take advantage of having that information. And I still think, we're talking about medical grade data. It is private, and it shouldn't be out on a market. Anyone that steals that, if I was to steal your medical information, that's a crime. So genetic
Or
data
social
is the same
security
thing. Right.
number. Senator Albritton, Senator, we're gonna go Weaver. Hold on a second. She was ahead of you. Sorry.
So I have a question, and I'm just sitting here thinking about the implications of this. So, a lot of times we see things like Ancestry.com or other places that have the DNA collection. So in a scenario where somebody gave their family those for like Christmas, and they gave people a bunch of them, and so somebody walks around swabbing everyone's nose. Well, maybe there's a nurse in the family, so they get the nurse to walk around and swab everybody's nose, and somebody else has the account, so then they send it into that person's account. Under this, those people would then be DNA and for having it in their account. Am I reading that correctly?
No. It says without their express consent. So if I said, "Hey, nurse cousin, can you take this for me?" I gave you the express consent to do that. Therefore, you would not be guilty of the crime. It would only be as if you did it without their consent. So imagine, go back to that example. You sent all the information into Ancestry. I then, as a hacker, hack in and steal hundreds of thousands of people's account, their data, information of their genetic data. I would have committed the crime because I obtained it without someone's express consent.
So is express consent, is that in writing? Is that verbal? Is that, what is that? Right.
In our code where we use the term express consent, we have consent, and obviously consent could be in writing. It could be a contractual agreement. If we go back to the Ancestry or the 23andMe or any of those entities, that's all written. It's memorialized into an agreement. If I ask my cousin to swab my nose, I'm probably not going to get a written contract with her to do that. However, I would say that you obviously expressly consented to someone to swab your nose or your mouth if you sat down and allowed them to do that. Your actions would show that you consented. I think that unless you are, there's an express consent if you sit down. It's not just implied, in my opinion. If I sit down and I say, take a swab, obviously I expressly consented. And then the only thing would be is even if I took that, I did a swab, only then if I then created the genome, would I be guilty of the crime. So if you just take the material, you're not guilty of the crime. So even if you swab your nose, if you held someone down and swabbed their nose, you're still not guilty of genetic theft.
Right. And then, you get into disclosure. Well, if one person had the account and everything came back there, that person would then be giving it to other people, just helping them get their results. And I don't know.
Right. Well,
it's just a little bit confusing to me.
I know. My experience with the Ancestries or the 20, each person has to have their own individual account. You can't have one account with multiple DNA sets.
No, you can't.
That. Okay. I know.
And you
I
can
know
have
23andMe
and
you
they
couldn't.
can all be listed under there.
Okay. I know 23andMe you couldn't. So, all right, yeah, that was the one that went bankrupt.
Senator Orr.
So you mentioned other states that have done this. How many? Where are they? Give us a little bit of context.
Well, Florida did it, and maybe the term states was improper as in the plural, but the state of Florida has done it, I know for a fact, and I can't say if any other states have done it. So Florida passed this, and the whole point was to protect medical grade data and how it may be used in the future, and to prevent it from being used without your consent or your permission.
I'll just say this, Mr. Chairman. I like the bill. As the world changes, people up to no good will find ways to use information like our DNA. And maybe that might strike some as overkill, perhaps, but if we don't put the parameters out there, that means it's just the Wild West and everything goes. So, the appropriate time, I'd move favorable on the bill.
Got a favorable by Senator Orr, second by Senator Van. Senator Albritton, did you have a comment or question?
I have a question for
Yes,
you.
sir.
Clarification. When we're talking about DNA, are we talking about the DNA record, the data? Or are we talking about DNA material, property? And who owns the DNA? If I give you my car, you've got the car. What you find in the car tells you a lot about how I keep my car up. But that's yours now. Is DA property like that? Or are we talking about just the sequencing codes and the data that should be medical records rather than property? Which one is it?
Well, I think you raise a very good question. Something, I mean, I've thought a great deal about with this is you're right. Where do you define what is property? And then is that your property? And then the moment you provide it to a third-party entity,
And if it's
is it
records,
their property?
If it's simply the records we're talking about, we already have laws dealing with medical records and the protections of medical records, I think federal and state.
We do. However, those backtrack and answer all those medical records only apply to a medical entity. You know, if I hand over, we'll use this as a better example. So when I use my phone, for instance, and it tracks my sleeping patterns or it tracks my heart rate, that's medical grade data, but it's not protected by HIPAA because it's owned by a private entity. And that would be the same thing if you hand it over to a non-medical, if a non-doctor has your genetic material or genetic data, it's not protected by HIPAA. And so what I'm trying to say with this bill is anything that is that genetic data, that genetic material is now protected. In essence, I don't say it's protected by HIPAA, but it would be a crime if you were to steal it or take it without someone's express consent.
But you can get DNA data without getting the DNA.
Correct.
And that could be on your phone, or it could be in the medical office, could be in or whatever. And the material is different because it's not worth anything until you analyze it and get it rendered. Anyway, I've got a lot of questions. I think it's a bill we need to consider. I just think we're a little bit unclear.
Senator Van, then Senator Coleman Madison.
So while I have an ever receding hairline and why I don't see the same thing in the mirror that I see on Capitol Journal, I'm not sure, but every time I do get my hair cut and some hair manages to be on the floor, that's a DNA sample. And if they take it, which they are going to take, the lady comes up, sweeps it up, and puts it in the bin. She throws it in the trash. No big deal. But nothing stops them from taking that material that every one of us that gets our hair cut, is going to have, that they could go run our DNA. And in that instance, if they get it, put it in the trash, it's no crime. They get it, go run a DNA analysis on it, then it is a crime.
Right, it would be a crime. And so I think that go back to the question of ownership, and to answer that, if I hand over my DNA or a sample, whether it be your hair, if I knowingly and consent say I'm handing that over for whatever genetic testing then that's me making that choice. But the problem is when someone has your genetic material or a genetic sample and they obtain that without your express consent. I mean, when we have federal laws on protecting all medical grade data, and this is medical grade data that should not be stolen. And who knows how those uses could be in the future.
Senator Coleman Madison.
Thank you, Mr. Chairman. I think a lot of this is already here. Most of us know it, but maybe we don't think about it. UAB has a genomics area where they do testing, and I did go over there to have that test. But when all the results came back, and it's very extensive about whatever you might have or could have, and I was very interested. And so he says, I normally send things or have them to send things to my doctor, but I decided to read this thick document just for my information to find out about it, because the very same thing that we are talking about is that, these third party, your insurance once you give it to your doctor, and then, of course, they share and they have access to it. But in there it says that, again, the question that came up, that you could be denied because there's something in your genetic background that you might contract a certain disease or whatever, or it was in your family, long shot, but nonetheless. So I chose not to share that information because of that. So, it's just too much out there. You touch something, no harm done, but it's how they use it. And so, without having some kind of protection, it's there. And right now, nobody's protected.
Understand, very
Right,
good comment.
and even to go to that point, once you, depending on the way Ancestry.com changed their contracts, they could just say, we're gonna sell your genetic data to every insurance company we want to. That's part of our business arrangement. We'll provide you with where your family came from, but at the same time, we'll turn around and sell your data and transfer it without your permission.
Good, robust discussion. Ms. Ogden, if you'll call the roll for me.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stetz? Senator Weaver? Senator Barfoot?
Aye.
7-2.
Very good, lawyer. You did a good job answering those tough questions. I think the robust discussion is helpful on
Oh,
it. So.
well, I enjoyed it. I probably wasn't as prepared as I should have been, but thank y'all so much for your time, and thank you, committee, thank you, Chairman.
Thank you. All right, next, and I believe last up is HB 380. Representative Rigsby is here. He is taking a second bite at the apple. Representative Rigsby.
Thank you, Mr. Chairman and committee. I am back with HB 380, and this is going to be kind of a same soup, different bowl discussion of what you just talked about. This is another one of those bills that's going to be a protection of what can come. A little bit of research, a couple little Google searches will tell you that the research behind reproductive human cloning is on the horizon, and so this bill will help to put up some guardrails to help protect that. We had some discussion last time about some definitions, but I'd be happy to answer any questions this morning.
Senator Weaver.
Mr. Chairman, I was the one that had the questions last time related to the definitions and any issues they may have related to IVF. I want to thank Representative Rigsby for working with me over the last week to hash all that out, and I think it's a good bill, and I think we're where we need to be, and there are other people that agree that it won't have any conflict with those definitions. So with that, I'd like to make a motion for favorable.
Favorable by Senator Weaver, seconds regarding the bill itself. All right, hearing none, any, well, I think we got a couple of no's on the last one. Call the long roll for me.
Senator Albritton? I'll go yes on this one. Senator Bell?
Bell.
Senator Figures? Senator Gavan?
Aye.
Senator Orr? Senator Singleton? Senator Smitherman? Senator Stetz? Senator Weaver? Senator Barfoot?
Aye.
10 in favor.
All right, Bill's given real quick. I want to say a thank you to Ms. Ogden. Holly has put up with me and does an excellent job of pushing me in a gentle way to give her the information she needs to set the agenda. And she is very helpful to me personally and to this committee. And then also Mike Harper, who, if you'll notice, Mike in his role reviews every single bill. I know that each of you have looked at his comments and probably had some questions based on that, so I'm appreciative of that. And then lastly, we wouldn't have this committee without each of y'all, and I do appreciate it. I have enjoyed chairing this committee. It sometimes can get difficult, it can get robust and discussions, but I think it's useful and it serves a purpose, and it's been my pleasure this year, and thank y'all.
Mr. Chairman,
Senator Smith.
I just want to say you've done a good job.
Well,
I mean, that, for some who don't, may not think of what I'm saying is just a nice compliment. But I've been in your shoes for 10 straight years. So I know how difficult that is. And more bills come through this committee than any committee that's in this legislature.
That's a fact. Thank you for acknowledging that. Thank you, sir.
Mr. Chairman.
Yes, sir.
I just want to acknowledge that for other members, she will rat you out to him if you're trying to pull a job.
We are adjourned.